my topic today actually will deal with this particular work that I'm doing now without really going into detail what I'm doing and how I'm doing it, because obviously I'm still in the middle of it. But it will actually try to use example of the Dutch state as one of the, I think, encouraging examples how in a post-transitional period one can deal with the harms done to the victims and the ways how to compensate it in a very public way. In order to understand to myself what I was actually doing now, I dug a little bit into different sort of academic discussion that my previous academic work dealt with. And for that, I've actually chosen the topic of interplay between legal governance, historical memory, and rule of law. And why I think that legal governance is so important. Even the previous discussion that we had about the ICC, and obviously all us who I believe belong to this international liberal community that really thinks that international and global justice system has its right of existence. I think the very existence of ICC actually is a very example how legal governance on a global and transnational level should be developed, and that even the ICC's meager results shouldn't be discouraging, but I think encouraging, that the fact that such institution exists means that we are on our way to take seriously legal governance at a global level. But what for me, why this legal governance was so important is that we do appreciate as ordinary citizens much more what legal governance means at our national levels, because somehow we instinctively understand that it keeps us safe, or safer. And I'm talking from a perspective of liberal democracy, one of the most developed countries in the world, I would think, and economically sound countries of in the world, as the Kingdom of the Netherlands. So what I try to do is to connect legal governments with another much more generally used concept, and this is the concept of rule of law, and to show how in a Dutch case concerning this topic, actually rule of law in its very normative but also practical implication in the Netherlands gave us this result. Not only that the Dutch state has accepted its responsibility for its unlawful behavior, because the three judgments of the Dutch courts actually call it that the state of the Netherlands acted unlawfully in Srebrenica. How actually this application of rule of law helped us to achieve this position. So before I explain to you what the case study so far is, obviously the topic, the title of the topic is Interplay between Legal Governance, Historical Memory and Rule of Law, the Netherlands High Court Judgment on the Culpability of the Dutch state in Srebrenica in 1995. In my introduction and abstract, I wrote that the role of the states in the commission of mass atrocities is of a great importance in understanding the past, as well as remedying the suffering of the victims in post-conflict period. So moving from this proposition, I actually made an excursion to a more international relations vocabulary and glossary, and I used the terms that are now circulating as concepts, and this is that concerning the violent past, regardless whether it's within the state or outside the state, internationally, the states can react to the past, a violent past, by self-inculpation or self-exculpation. Well, self-inculpation means that the states embrace accountability and the rights of victims. So and by self-exculpation, it means that the states react to the past by historical selectivity, and arbitrariness. And whereas in the criminal legal proceedings, every individual defendant has been protected against self-incrimination or self-inculpation, we actually, as a world citizen, expect that the states will admit the wrongs done by predecessors' regime or the current regimes. And we somehow expect that the state embraces and deals with its own accountability according to legal and moral norm set in the human rights and international humanitarian law framework. We also expect that the rule of law as a normative framework will be shared by the same vigor by democratic and undemocratic states. This is a norm that we liberals think should be accepted. And then the reality shows something obviously completely different. So the ruling of the Dutch Supreme Court from July 2019 orders or rules that Dutchbat acting under the UN flag has been found responsible for not giving a choice to the refugees at Potocari compound on 13 July 95. And I will argue that it is an example of how legal governments and the rule of law in a functional democracy can compel the state, a state, to accept its own responsibility and act accordingly. Due to this ruling, the victims and their families will be compensated and the historical memory will be influenced accordingly. And I'm talking here certainly of Dutch historical memory and maybe even collective memory. But the judgment itself has some interesting open-ended descriptions that not everyone in the Balkans, in the Yugoslav states, will be happy with it or share the historical memory as this judgment actually describes. And we shall also argue the jurisprudence of this 2019 judgment has also set a new legal standard for the victims who seek the compensation of suffering inflicted by political violence, even when we talk about international peacekeeping processes under the UN flag. Obviously, before we go into the chronology of the legal steps in this particular case, I think it would be interesting to go back to something that we all use every day, but very often we do not quite understand what we are referring to, and this is the concept of rule of law. Legal governance is obvious that a law will be applied in order to regulate a certain events. In this case, we will argue that it's also regulation of historical memory that we see with the application of already existing laws in the Netherlands. So this is interesting continuation of discussion before. As Reinhard said, we do not all the time need to amend or change existing laws. We can apply the existing laws, but then what we would need to have is this framework of rule of law that every functional democracy should actually apply in a so-called thick way. You know that all these normative systems these days have a thin version, which is actually the normative framework, which is flat and taken for face level value, and then thick approach where you see that rule of law is actually going somewhere, that it's applied in the reality. So if we go to the history of law, actually one of the things that many of us, few of us in this virtual classroom who attend our other courses in Dubrovnik, there is a tendency, and I hope Sir Geoffrey and Sunchana might join to discuss it as well, that in a post-Cold War world, the rule of law and an application of law is becoming some kind of new religion. Only if we have a belief in rule of law and apply the law, everything is going to be fine. So it is much more question now of belief than what we see in the reality as a dividend of it. So if we go back to rule of law and say, no, it is not just a sort of new religion, it is a concrete thing that should be repeated and defined all over again for lawyers and non-lawyers to understand what it is. So we see that it has a historical background in the work of a British scholar, Albert Van Dicey, from 1885, and that he identified first three important issues, and this is supremacy of law, including the absence of arbitrary exercises of power, B, equality before the law, and C, judicial protection. And the supremacy of the law contains references to the importance of clear, transparent legislative process, as well as to the presence of foreseeability. And then we have 2011, the European Commission for Democracy Through the Law, or Venice Commission, denomination of the rule of law should be, and it identifies 6 elements: the principle of legality, legal certainty, the prohibition of arbitrariness, access to justice through independent and impartial courts, respect to human rights, equality before the law, and non-discrimination. And then we have from there, the European, the EC released a communication to the Council of Parliament on a new framework for strengthening rule of law, where we still have 6 elements coming back: the principle of legality, which is basis for legal governance, obviously, legal certainty, the prohibition of arbitrariness, independent and impartial courts, effective judicial review, and respect for fundamental rights, and equality before the law. So these are actually very good and helpful deconstruction of rule of law that could be applied for research on what was happening in the case of the Dutch state when it comes to the to this very important judgment. So what actually happened? The facts about what happened in Srebrenica might be matter of general knowledge, but basically in the war in Bosnia and Herzegovina that lasted from 92 to 95, there is a robust presence of UN peacekeepers, and at the time UN had only 3 instruments how to deal with armed conflicts. It obviously had a mechanism of peacemaking, peacekeeping, and humanitarian aid for the areas in the crisis. It definitely, absolutely did not have peace enforcement. And despite the peace presence of UN from the first to the last day of the war in Bosnia and beyond, and despite the fact in 1993 there was this International Criminal Tribunal for former Yugoslavia, in 95 we had actually culmination of genocidal process in Bosnia and Herzegovina, where after 11 July and 95 and fall of enclave of Srebrenica, the Serb forces, security forces, took from the Srebrenica area more than 8,000 young boys and men who were accordingly executed. And the Dutch story is an interesting story. Dutchbat came there to replace a Canadian battalion. They came there in 94. They were they had rules of engagement that were defined by UN, and in rules of engagement, they were lightly armed, and they were not to engage in any combat situation and use their weapons except in self-defense. And that was in stark contrast with the other UN realities, and this is a resolution from 93, UN resolution from 93 that pronounced Srebrenica a safe area. So it was not safe haven, it was not safe zone, it was safe area, and the wording was very important because in this wording, UN actually precluded its obligation to protect by force the area. And what was happening and why these class action by Organization of Mothers of Srebrenica that was representing about 6,000 next of kin, family members of deceased and executed people. Why was it so, so important? What they basically did, they said that if Dutchbat was doing their basic duty, that people, young men and boys, who were at that time in Potocari compound would still be alive. So they went, the chronology of this legal process is fascinatingly straightforward. It was not that complicated as one would think. So first of all, the mothers of Srebrenica needed to have became a legal person in the Netherlands. So, and then they addressed the Dutch court first by actually trying to inculpate UN. And in the first stage of the class action, which started in 2007, all Dutch courts, including the Supreme Court, confirmed the immunity of the UN. And once immunity of UN was gone, there was this legal construct still to make the Netherlands as a state culpable for what happened and what went wrong in Srebrenica, and they succeeded. So from 2007, the first judgment, first instance judgment was in 2014. And this judgment basically found that the state of the Netherlands was acting unlawfully on 6 points from the lawsuit by the next of kin. So I can give you a few examples. I'm not going to read all of them. One is that they militarily simply abandoned the blocking positions. This is a military term, meaning that they did not block Serbs' advancements to the enclave, which at that time is protected UN area. They did not give adequate medical help to the refugees. So the fascinating language in the judgments is that those victims of genocide are called the refugees. And that's also simply shows, I think, the idea that Dutch said we didn't know that genocide was in making and we could not say victims of genocide. That all weapons had to be surrendered to the Bosnian Serbs, and that no refugees were allowed to enter the Dutchbat compound. For many of you who don't know how it looked like, Potocari compound was a military headquarters of UN protection force, in this case Dutchbat. And it could provide space for a few hundred people. But Srebrenica by itself is overpopulated by refugees from the surrounding villages as well. So outside of a compound was another camp of few thousand people, more than 1,000, who were trying to find a safety within the compound, and they couldn't. They were not allowed to enter the compound. And then the last and sixth point where the 2014 judgment found the Dutch state acting unlawfully is that Dutchbat helped dividing men from the other refugees during the so-called evacuation process of children, women, and elderly. And that by that act, they were actually aiding the Serb forces in commission of crimes. So the court decided that the state acted unlawfully and was to pay compensation for the next of kin. And both sides went appealed the decision, and the appeal judgment came in 2017, and from all the criminal acts, or not criminal acts of unlawfulness, not criminal acts, the 2017 judgment actually found the Dutch state guilty on two important points. One was that Dutch state, and Dutchbat in this case, did not protect men from being executed, where actually this division of dividing men from, say, 16 to 60 from other refugees. But the second issue, which is very important from the end of this whole process of court judgments, is that from those men who were within Potocari compound, the Dutchbat did not offer them the chance to say whether they want to stay or leave. And in this judgment, actually what is interesting, the court decided, so it is appeal judgment from 2017, the judgments decided that because of not offering the men chance to stay, the state was to compensate them for 30% of suffering. I'm reading from the Dutch documents. I did not have any of these in English, so this is why I have to stutter a little bit. And so this 30% would be the concrete measure of compensation without anyone saying what is the total compensation that is there and what then 30% should be. So this was 2017, and in less than 2 years' time, or about 2 years' time, there was the decision of the Dutch Supreme Court that basically reversed the unlawfulness when it comes to not protecting the men altogether, but that Dutch state acted unlawfully, not giving a chance to those men who were at the Potocari compound in the afternoon. So this is very important. In the afternoon of 13th of July of 95 in Potocari. So we are talking probably about, and they said that we are talking probably about 350 men. This is the judgment that was reason for the Dutch state to form a commission for implementation of extra court settlement for Srebrenica. We call it now, in short, the Potocari Commission, because the idea is that it shouldn't be connected with the whole Srebrenica crime that was happening there, but it should be really narrowed down to where the Dutchbat was in charge, and that was Srebrenica. So what happens? On 30th of July, the Dutch official gazette publishes the composition and the mandate of this commission. The commission now is defined as an independent commission, which is a little bit, I think, a play of the words, because commission was appointed by the state and is financed by the state and reports back to two ministries or two ministers, Minister of Defense and Minister of Foreign Affairs. And the mandate of commission is to find out who were these 350 men, plus minus, who were and who are the next of kin that are eligible for compensation, and to give them a chance to come to agreement with the state without going again to the court. And commission is operational from 30th of June, I'm sorry. So commission is operational from July this year. And by the end of this year, they are going to present their findings, first findings about the identity of the victims and their next of kin. And then the Ministry of Defense and Ministry of Foreign Affairs, on personal authority of ministers, will have a budget for the compensation, which is still unknown. And at this point, there will be some sort of accounting what is the sum of which 10% will be paid to next of kin. In the definition of next of kin, there are two categories. Category one is wife and children. Category two, father, mother, brothers and sisters. And category two will be compensated only if they can prove that they are part of one household and they economically dependent on each other, which was usually the case in these rural areas in Bosnia. And second thing is that in Dutch law, there is no immaterial compensation, just material. So it means the fact, just to give you one example, interpretation so far is that material compensation is only for those who were executed, who lost their lives. But if someone survived, it does not, probably will not be eligible for compensation. So these are all fine tunings for which no one still knows how it will work out, but whatever will be decided, there will be a justification for a protocol explanation. So I think it might work very well in the, maybe in the future for other similar cases, and certainly for the Netherlands, because for the Netherlands, it is not the first compensation commission. So Netherlands is paving the way in a very quiet way. So two things that I think might interest you. One thing is that in engaging with the victims community, the most important way to do it is based on empathy, understanding what is their suffering and what they had to go through in the last 25 years, especially the long waiting years to get any sort of satisfaction of and recognition for the harms they went through. And because of this approach, the way for application for compensation is that it should be a low threshold and that it should be very easy to apply with a minimum of requirements in the form of documents and so forth, etc. So this is needed to minimize the efforts and anxiety, and secondly, to maximize the speed of compensation really getting to the right hands. And at the end, what I think is making many of Dutch state taxpayers proud or happy is that the general reaction from a broad Dutch public is that they all agree with it. You would not have one negative article, op-ed, public discussion that actually is against this, what Dutch state is doing to compensate for the suffering of victims and survivors, next of kin of in Srebrenica. And with the disclaimer that the work has not been done, and that once the work has been done, that probably a lot of people in the society in Bosnia will react violently to whatever regulation eventually will work out. But this is a situation that I think many of us, you also, who work with post-transitional justice, transitional and post-transitional justice processes, do understand that there is very difficult to know and understand what measure of justice is the right measure. And at least this way of compensating next of kin and survivors of a genocide by a third state, like Dutch state, that was not there for its own interest, but under UN flag, is for me a very encouraging step in a, I hope, very good direction. Thank you so much.
Thank you, Nena. This opens your lecture is the last lecture of our course, which shows what happens in the aftermath when the redress comes and we expect victims to get some sort of compensation. I think the case, as some of the students already written some interesting questions. Okay, let's start with the questions, and then let's come to the conclusion. What is lessons learned, what we can, although it's still in the process, what we can learn from this, and what should be avoided when in the future we will be discussing redress to victims of serious economic and environmental crimes. So let's start. You can follow chat, please, Nena, as well.
Yeah.
Wait, I have to go up a bit. Let's start with Maria. In your opinion, how do states react to the violent past, which has been perceived as embracing accountability and the rights of victims. And then maybe we can link that question to Hrvoje, but Hrvoje, you can also please get involved here. After 25 years, don't you think that this ruling of the Dutch Supreme Court means more for the Dutch society than to the victims of Srebrenica genocide? Of course, he agrees the ruling is important. Maybe you can add, Maria and Hrvoje. How do states react? And 25 years, for whom is the justice now? For the victims or for the state? And what does it mean for the future when we are talking about atrocities crimes?
Well, just, you know, what you are now asking were obviously also the questions all of us who work one way or another in these sort of topics. But and the question is, when I started this and I went to figure out how state would, should, and have been reacting to their own roles in commission of crimes, either directly, indirectly, or and finding this concept of self-inculpation and self-exculpation was sort of interesting, because basically what this case says of Dutch state is that no state is ever going to admit to its own wrongdoings, certainly when it comes to commission of mass atrocities voluntarily. So Dutch state did not say, okay, we have done it. But what is so important for me here, that because of the rule of law, and I read all these 6 important elements that constitute our modern understanding of rule of law, is that we have a system where we can address it, and we have independence of the courts. And a class action of citizens, what you were discussing previously as well in environmental and economic crimes, actually had access to the court institutions, where state was a very, very severe and fierce defender of its rights. Do not think the Dutch state just said, oh, shoot me. No, they used all possible legal means to their disposal to fight against these accusations or unlawful charges of unlawfulness. And for me, it is not that any state, in this case, not Dutch state, are improving their behavior, because states have a huge prerogatives in the international state system. They have power, and they are not going to surrender this power just because a group of people, 6,000, starting action of them. So for me, more important thing is that it shows that the rule of law, if developed and applied in a democratic state, can help to bring us to these results. And once there was a Supreme Court judgment, the Dutch state simply said, okay, how do we deal further with that? Are we waiting for each or for a group of people to get us to court and to enforce compensation, which process that might take another few years? Or are we going to say, this is the ruling, we respect it, and we are going to find a way forward, a settlement? So I hope that explains a little bit the question. And as for Hrvoje's issue, you know, 25 years onwards, the world changed very much, and we are very happy if we can keep up the memory about Srebrenica alive from year to year now. And for Dutch society, I'm not talking about Dutch state, situation is such that new generations were not even informed at a school level what happened there. And once, you know, we who read newspaper at that time, we have it as in a fresh memory. But how do you keep up historical memory? And this is in the title of my presentation. And I will tell you that as I give lectures at Department of European Studies, and we do put lots of emphasis on a system of values. you know, what are the values within European culture and so forth, etc. And memories of harms done and mass atrocities in Europe should obviously be kept alive, just for all of us to continue learning about shared and common values. And I must tell you that just last year, a student of mine wrote a BA on Srebrenica and the Dutch school system. And she was shocked that none of her friends, and she went to this gymnasium school, knew about it. But the good news is that Dutch are going to put information about Srebrenica in the, they call it history canon for the next generation of school books. So there is an effort to keep it alive, to keep it important in the Dutch history, but, and I think not just in the way to tell all the truth, but also to control the narrative that will not be too harmful also for the Dutch state. And this is where state have a huge power to do, but also they wouldn't be able to do anything they want if we didn't have these legal governments and rule of law. Without these judgments in the Netherlands by the Dutch courts, who knows how much more space historians, out of bad intentions, of ignorance, and sometimes simply because by chance, would actually be more able to form, create a narrative that would not show actually extent of role the Dutch state and Dutchbat had by not protecting as many victims that they maybe could have done.
Yeah, I mean, yeah, that's very important. But when we're talking, I know, for instance, Congo and Belgium, and it applies, I don't know how it is in other countries, not all of them at least, but I think that his history and historic narratives should also include more these atrocities, either connected what happened in Srebrenica, but also what happened, for instance, by exploiting, to connect with the topic of natural resources in former colonies. That also refers to Netherlands. So in general, this is the question, okay, we are mainly lawyers here, but we should be aware of it, that not new generations are not really aware of these atrocities connected either with exploitation of natural resources, genocide, environmental damage that is occurring. And that is the problem in my mind. So it's very important what you notice, what you shared with us for Srebrenica. I'm just saying that it should be done more consistently to much more atrocities that are occurring. Yeah, but let's continue. We have the question of Lara. Can you follow, Nena? Did the accountability of UN disappear into a black hole? Yeah, due to its immunity from the jurisdiction of Dutch courts. What is your opinion on it?
You know, when they started with UN, first of all, one of the practical things, some Dutch lawyer and one Axel van Hogendoorn, he works here for, he's a German lawyer who works here in the Netherlands. He said when they started actually even thinking about this sort of lawsuits, that they knew they cannot go first after a state. They needed first to go after UN, knowing that there is no court in the world who would ever felt competent or having jurisdiction to deal with the immunity of UN. But they said, or at least Axel said, and he was in Dubrovnik once lecturing about it as well, that and their website you have their filing, historical filing way back. And then he said that they felt that they had chance to win only if they got that hurdle out of their way. so that Dutch court says UN, we have no competence to actually deal with this issue. And then he said after that, the lawyers could tackle the unlawfulness of and responsibility of Dutch state, which actually happened. So basically what I'm saying, what I heard from him, what I know from him, they never thought they would succeed. Mm-hmm. I don't think any court would. If anyone of you has a good idea or example, you are very welcome to share it with us. But in this case, I don't think it was an issue. And at two different levels, a Dutch judicial system, that was the decision that the community of UN was not tackled.
Before moving on to Mare, but maybe we should leave this question that concerns jurisdiction in general. Let's see, Anna. I don't know if Anna, you have a mic or not, but Anna is in the Netherlands. Have you
Yeah.
One comment on immaterial damages in the Netherlands. As I'm a Dutch student, on the 1st of January 2019, a new law came into effect that also allows compensation for affection damage in some cases in the Netherlands. Affection damage refers to the situation of the death or serious injury of a close relative. Of course, this only came into play in 2019, and it's very strictly used and very new within the courts. But it is now being made possible. Thank you, Anna, for that. If you want to add something, maybe it's connected to what you were saying about the problem of damage compensation.
Mm-hmm. Yeah, Anna, these are the things that are very much under review at this point. So what I was telling you was from the working manual that is sort of applied, but obviously if this becomes an issue, then I'm sure there will be a legal reaction from the side of the Commission, not from the Dutch government. Because if there is a room to apply this, that will be task of Commission, that because Dutch government is a party to this process. So I'm quite sure that Commission will deal with that if it's relevant, but as the manual was when I read it, it wasn't relevant. Immaterial damages were not relevant. Why? I'm not sure. I couldn't give you an answer. I don't know.
Okay, thank you. And we have maybe jurisdictional issue concerning which crimes. Mare, you asked where I lost.
Where is it?
What about the ICC in this matter?
You know, this is what Jeffrey and Sunchana and Reichert were talking about. You know, if you do these sort of class actions at a criminal court where you have only possibility and the only way to do it is to prosecute individuals, you know, in a class action and damages, you don't get anything. How could you go after Karadzic to compensate for huge material, immaterial losses while he's sitting in jail and bankrupt? So whom do you go? Whom does he represent? Republika Srpska. What is Republika Srpska? Does Republika Srpska has a budget? You know, so you always end up to a state or big multinational or actually, and then you don't go to criminal court, or you go to criminal court. But then if you really want damages, that's a completely different issue, because criminal court won't get you damages you deserve as a victim.
Yeah, then it should be connected, criminal, then conviction, and then damages separately. And this is also the lesson learned for economic and environmental.
But only not only that, you know, I am a huge supporter of international criminal and judicial regime, you know, because I think we need legal governments on a global level, but when it comes to these sort of concrete issues, I'm not a lawyer, I'm just telling you from my own personal experience in the cases I've been doing. National jurisdiction, if these elements of legal governance and rule of law are thick in the way they showed to be in the Netherlands, provide enough to compensate for damages. And then the question is which state have jurisdiction after which you can go. But this was a very good example where all this came together with the result that I think whatever the monetary compensation is, I think that historically, this is a good example that you can resolve these issues at the national jurisdiction.
Yeah. Well, thank you. Thank you, Nena. We opened so many questions here during this course, and I hope that you all came to new ideas, to see the new possibilities, and to be aware that lots of work is ahead of us, but it's something that it's on us that we try to change something and improve the legal reality and political reality.
May I say something? I'm very surprised that no one of you asked why 10%, because this is one of the biggest point of criticism from the region, that they say, what is the human life worth? And that, you know, first it was 30% and then suddenly 10, and people were saying, out of what? What is the maximum price we have on a human life? And that's something that is quite interesting how it was going to play out. But one of the answers you could say is the fact that Dutch system works in this sort of way, that it found its own state culpable for unlawful behavior at very limited level, doesn't mean that the other states who are more culpable and do not have such a system at stake will stay out of the picture. Why should Netherlands pay 100% of the damage while other states remain silent? For example, Serbia. And another thing that I told you, that the judgments of a Dutch court, and actually many, many other judgments in civil lawsuits as well, give extremely limited factual, political and historical background of the conflict. You know that the Serbia as a state was not mentioned one time in any of the Dutch official, semi-official documents about what happened in Srebrenica. It was all at the level of Republika Srpska. And Republika Srpska is not a state. So which state is going to be culpable for genocide in Srebrenica? Bosnia and Herzegovina is culpable of, because Republika Srpska is not a state. So that's another fascinating thing. And this is why I put historical memory in it, but obviously it's not a right place or time. And I'm not so far with my research neither, because it was just the beginning of developing the thoughts about it. So 10%, and my question was, and is, how are we going to get to know whose responsibility is the rest 90%? It's a good way to finish this debate, because I have no clue.
Yeah, we have Judge Turkovic with us. Thank you. And then Jeffrey wants to say something. Yes, you are right. And I can see an immediately problem with business sectors and companies, and which state and whose players and which territory, who is responsible, one hand that goes, one that it doesn't prevent, others who participated. Please, the floor is yours now.
Me?
Yes.
Thank you very much. Well, I just would like to reflect on what you were talking today, and would like to come from the perspective of the case law before the European Court of Human Rights, because we have a number of cases that are coming against Croatia, against Serbia, and against Bosnia and Herzegovina. Unfortunately, the cases against Serbia and Bosnia and Herzegovina are finishing as single judge cases, and they are not dealt with on meritorious level. And that's very problematic for the court, I think. But, you know, there are different reasons for that. But luckily, the cases that are against Croatia, and I am a Croatian judge in front of the court, they really do come, and they are really decided at the level of the merits. And we are getting several types of cases. Cases that are related to the war crimes, that are related to Article 2, the life, the taking of the life, Article 3, no, torture or inhuman and degrading treatment, and then Article 1, Protocol 1, and these are cases that are related to the compensation. And it's interesting to look at that whole arena, the whole area in a holistic way. What the court can do, the court can only find procedural violation for the states from former Yugoslavia, because the whole conflict was before these states became members of the Council of Europe. So the procedural violation that the court can find is the violation of the effective investigation. And when there is no effective investigation. And against Croatia, in 4 cases, the ineffectiveness of the investigation was found. And the many other cases that were related to the ineffectiveness of the investigation in the normal crimes, the result of that finally was that the last year, Croatian Constitutional Court started to look at the effectiveness of investigation. And from the perspective of the war crimes, this opened very interesting issues, because what European Court of Human Rights cannot do, cannot go into the substantive violation, because this is from the perspective of temporal jurisdiction outside of the jurisdiction of the court. But once Constitutional Court starts to look at the effectiveness of investigation, Constitutional Court can look at the substantive violations. And when you find violation of effective investigations, in 95% of the cases, for the court, it's possible to find substantive violation. So, for example, we have the first example of the Constitutional Court judgment from the beginning of this year, where the Constitutional Court of Croatia has found violation of the effective investigations, and on the basis of all the facts that were in front of the court, violation of the substantive violation, so that the war crime was committed, and the responsibility of Croatian state for that, which opened for the Constitutional Court the possibility to give the compensation. And Constitutional Court did that. And now the case has come back to our court, to the European Court of Human Rights, that the compensation was not sufficient. So see, now European Court of Human Rights could react on the level of the compensation. So the whole issue is coming actually, and how it is resolved, quite close to what it is done in front. But there you have a class action, here you have individual actions, but you have a number of individual actions against Croatian state and against, you know, that now can be dealt at the level of Croatia, which gives greater possibility to deal with you know, bigger set of issues than the court can deal with. What is unfortunate that the court is not dealing with the cases against Serbia and Bosnia and Herzegovina, where many more atrocities have, or, you know, more culpability is there maybe. And I hope that in the future that could be resolved in front of the court. But the way is opened, and it's coming quite close, you know, to what the Dutch government was doing. So I just wanted to that you can have that. Yeah.
No, it is perfect. What do you think? What absolutely amazes me, you know, because the crime of genocide is the only crime that is, you know, that comes from the UN convention. So we don't have a convention. Crimes against humanity and war crimes in the same level. Do you think that a crime of genocide makes actually much more chance for class actions, certainly against other states than the Netherlands? Or do you think that?
Well, but I don't know in front of which court you would like to go. For example, in front of the European Court of Human Rights, we are not dealing with class actions. So we are dealing only with individual actions. So with class action in front of the European Court of Human Rights, you do not have any chance. It will be out immediately, you know, because it is not. But individual cases, when they are coming in front of the court, yes, they do have a chance. They have a big chance. But as I have told, they have a big chance in terms of the effectiveness of investigation, not substantive violation, because this is outside of the temporal jurisdiction. But once when you force domestic courts to deal with the effectiveness of investigation, then you open the possibility, because for them there is no time limit, no? Especially because these crimes do not have a time limit. And then constitutional courts of these states, or whichever court can deal with the effectiveness of investigation, has the open possibility to deal with the substantive violation if there is not willingness of the prosecutors or of the courts to really deal with the issue.
You probably do understand why I'm asking this.
Yes, yes, of course.
You know, because if we even get to the number of 350,
yeah,
you know, it's a small success, but actually you feel a complete total despair. What about the others? You know?
But I think the biggest problem in at the level of the all states from former Yugoslavia is the way, you know, even within the existing legal framework, it would be possible to find to find the possibility to give the compensation with a little bit broader interpretation of the civil law and the statute of limitation and the responsibility, and the law is providing the way for that. I think that with the new judgment of the Constitutional Court of Croatia, there is a way where the Constitutional Court or the European Court of Human Rights maybe in the future could show that way, you see. But for now, all the states are interpreting very formalistically, and they are all saying the statute of limitation for the compensation is 5 years, and for everybody these 5 years have, you know, passed a long time ago. So it's very difficult at the domestic level to get a compensation if you do not find and you don't prove the name of actual perpetrator. And the state is somehow hiding behind that, not taking the responsibility to pay at the moment when it is clear that the state forces were responsible, but you don't have the name of actual perpetrator. And that is a hurdle that should be overcome. And once it is overcome, then you have the possibility to have the responsibility of the state, the compensation of the state without the statute of limitation, because these are crimes without the statute of limitations. Why? Because all of our countries have the law which says that if the crime was committed, then the statute of limitations from the civil law do not apply, but applies the statute of limitation for that particular crime. But somebody has to be convicted for that crime, no? And what is needed to be done, that is sufficient that it is found that state forces are responsible for that, without finding the, you know, the exact perpetrator. But it is clear that the state forces of certain state are behind that. So there should be done that, you know, somehow that should be overcome. And there are ways to do that. And I hope that, you know, with time, this will be clarified and will be possible to do. And I think that the Croatian Constitutional Court really has opened the door for that now.
Mm-hmm. Wonderful. And what about the ICJ decision on Bosnia versus Serbia from 2007? Serbia was found responsible for not preventing genocide. Would it be something that could be taken further then? For
well, you could look at that. I don't know. I was not thinking about that, so I don't want to talk like
okay.
that.
No, it's fine. Yeah, okay. Thank you so much. Very helpful. Thank you.
Yeah, thank you. Thank you very much. I have here Jeffrey, who wanted to share his thoughts before we end.
Oh, thank you, Snježana and Nena. And I only wanted to make 2 points. One specifically because I was asked to touch on it, and that is whether laws become a new religion. And I only want really to note this, that empirically you can see that law and lawyers invades all our lives much more. In very many countries, the number of lawyers rises all the time per per million of the population, you can see in all our countries how law occupies more and more of the space of social life. And one of the reasons we turn to the law is because, and I'm quoting actually now from something that quite a famous judge, whether you like him or not, who wants these days to be a talking head, Lord Sumption, said, and he said, the role of social and religious sentiment, which was once so critical in the life of our societies, has largely been taken over by the law. Internationally, we have no single religion to guide us in the way we behave ourselves. There is no single philosophy to guide us, and thus we do turn to the law. And so that's one reason why I think you can think of, or start to think of, law as a new religion. And the second point, which I'll try and deal with very shortly, is simply to agree with and endorse what Nena says about states not owning up to crimes that they've committed, and they never have done and they never will, whether it's England hiding its criminal past in colonial wickedness and slavery, or whether it's modern day criminality. States just don't own up. There is a complete hypocrisy. They expect the person who drives a car at speed to plead guilty. They hide their own crimes. And my last observation, which Nena may want to comment on, I don't know, is that, and when she made the point about 10% only attributable to the Netherlands, there is evidence, much of which, all of which Nena knows about, going to show that the role of other states in Srebrenica, in particular America, England, France, Germany, as well as Serbia itself, are all hidden, and we can prove that they're hidden because they have all kept back documents for precisely the Srebrenica period, all of them. And there's plenty of material about that, and it's a real sadness because the correct apportionment of responsibility as between guilty state parties is never going to be available, or not for a very long time. Thank you for letting me add those 2 points.
Thank you, Jeffrey, for this very important point. We can see already Durkheim, that Andy pointed us to Durkheim here. With that, I would like to give a floor to Mark. Mark, can you hear us? Mark?
Yes,
Okay.
I'm here. Can you hear me?
Yes, we can.
Yes. Okay. So I'm already on the train, so excuse if I'm not so completely with you today. But before we end the course, I just wanted to say thank you to all the ones that contributed, and to all that are really into the topic. And I think we have seen so many aspects to this week, and seen that there is so much work to do, that we really can get started tomorrow. What was kind of a bit most interesting for me to see this week, I think we all agree that global problems need global solutions, also meaning that especially in Europe, where we have so much legislation, we need some more progress on the topic. And it's quite nice that especially the Commission has taken up the environmental topic. But what we have also seen is that the law as it is on the international level is very fragmented and often very diverse, because it's, especially on the international law level, very much connected to these core human crimes that we have. But we see, and I think we've seen this week, quite many ways to open up and broaden that a bit without losing I would say the core elements that this international law tried to, well, take up. And that's meaning that these are issues that really concern humanity as such, and that these issues do not only concern the classic war crimes and genocide, of course, they do, but that we have other problems that might also affect a larger number of people that should be addressed, not only on the state level too. What is quite remarkable also for me is that we have almost all agreed that classic international law has now changed. It's not just about the liability between states. Of course, that's still an important factor, but we have talked so much about individual liability. We have so much talked about human rights and of victims, of persons that are affected, and how we can build a system on the individual within international law. And I think that's one of the main things for the future, that we build a law system that has the individual in the center on international law, and is really going away from this state-centered perspective. And so far, thank you very much from my side. I really appreciated having you there. And what I think is quite good, that we have all these presentations now then online. So for the first time in the future, we can also look back at the course and take up aspects that are already there. So thank you very much from me.
Thank you, Mark. Maya, do you want to just also?
I said I didn't, but now I have to. Anyway, I'm not going to add anything.
Mark?
Yes, sorry, I mute myself.
So we know he's not listening to me, at least. Anyway, I don't want to add anything in substance. I think Mark summarized it really well. What I do want to say is that was a very interesting week indeed, and I also want to thank Sunčana because she really took up the burden of organizing this course this year. And I have to say that I'm always skeptical, that's my personal trait, but I was a bit skeptical of how it would work in an online environment. And I think we actually proved this week that really we can have a course even if we cannot meet in person, and that this is a sustainable model. Obviously, it's much nicer when we see each other, but looking from the other side, I think we saved a little bit of energy for our planet by reducing the traveling costs. I mean, not just in terms of financial costs, but also in terms of pollution that we cause by traveling so much. So this is just one note to end with from my side. So thank you all. It was a wonderful week, and I hope to see you soon.
Thank you, Maya. Thank you, Mark. Thank you all. Thank you, students. I mean, it's the end of the course, and I think that again we learned a lot. We addressed what is ahead of us in international criminal law. We expressed our concern that core crimes, as we understand them today, are maybe not enough to tackle challenges of globalization and state of affairs in the world that we live in, especially concerning violation of economic, social, and cultural rights. Great environmental damages, roles of businessmen, companies, the right to health. This is something that is expecting us in the future, especially the generations of students that were with us. And my special thanks goes to our participants. Of course, lectures are great, carefully chosen, and I'm very happy that you were all with us.